Companies Act, Section 203, Appointment of Key Managerial Personnel. Section 203 of the Companies Act, 2013 mandates the appointment of Key Managerial Personnel, KMP, for certain classes of companies and outlines the process, qualifications, and restrictions regarding their appointment. This section aims to ensure that companies maintain effective management structures by having designated personnel responsible for key operational areas, thus promoting transparency, governance, and accountability. 1. Requirement for appointment of key managerial personnel. A. Class of companies requiring key managerial personnel. Subsection 1 of Section 203 specifies that every company belonging to a particular class or classes, as determined by regulations or prescribed by the government, must appoint certain individuals as key managerial personnel. These positions include the following: Managing Director, MD, Chief Executive Officer, CEO, or Manager. This individual must be appointed on a whole-time basis. If no MD, CEO, or manager is available, a whole-time director may fulfill this role. Company Secretary. The company must appoint a whole-time company secretary who is responsible for ensuring compliance with corporate governance and legal regulations. Chief Financial Officer, CFO. A whole-time CFO must also be appointed to manage the company's financial operations, reporting, and compliance with financial regulations. B. Restrictions on appointment of chairperson and MD/CEO simultaneously. The first proviso to subsection 1 imposes a restriction on appointing an individual as both chairperson and managing director, MD, or chief executive officer, CEO, simultaneously. Specifically, after the commencement of the Companies Act, 2013, an individual cannot hold both positions at the same time unless one of the following conditions applies. The articles of the company permit it, if the company's articles of association explicitly allow an individual to hold both positions, this restriction does not apply. The company does not carry multiple businesses. If the company operates as a single business, the restriction may not apply. Exceptions for companies with multiple businesses. The second proviso provides an exception to the restriction mentioned above for companies engaged in multiple businesses. If the company operates in several sectors and has appointed one or more chief executive officers for each business sector, the restriction on holding both the chairperson and MD/CEO roles does not apply. This exception is subject to a notification by the central government. 2. Appointment procedure for key managerial personnel. Board resolution for appointment. Subsection 2 of Section 203 requires that every whole-time key managerial personnel must be appointed through a resolution passed by the Board of Directors. This resolution must specify the terms and conditions of the appointment, including the remuneration to be paid to the individual. This ensures that the appointment is formalized, transparent, and documented. The resolution acts as the official approval for the appointment and helps ensure that the appointed key managerial personnel have clearly defined roles and compensation arrangements. 3. Restrictions on holding office in multiple companies. Limitation on holding office in more than one company. Subsection 3 places a significant restriction on whole-time key managerial personnel by stipulating that they cannot hold office in more than one company at the same time, except in cases where the company is a subsidiary of the primary company. This ensures that key personnel are dedicated to the governance and operations of the company they serve, minimizing the potential for conflicts of interest and ensuring proper focus and responsibility. However, there are some exceptions and provisions under this subsection. Directorial positions. A key managerial personnel, KMP, is permitted to be a director of another company, provided the board of the primary company grants permission for such a dual role. Grandfather clause for existing appointments. the first proviso to this subsection offers a transition period for individuals holding office in multiple companies at the time the Act came into force. These individuals have 6 months from the commencement of the Act to select one company where they wish to continue serving as key managerial personnel. Dual role approval. The second proviso permits a company to appoint an individual as its managing director even if the person is a managing director or manager of one other company, provided that this appointment is approved by a board resolution. This resolution must be passed with the consent of all directors present at the meeting, and the meeting and resolution must be notified to all directors present in India. 4. Vacancy in office of key managerial personnel. Filling vacant positions. Subsection 4 mandates that if the office of any whole-time key managerial personnel becomes vacant for any reason, the Board of Directors must fill the vacancy within 6 months from the date the office was vacated. This ensures that the company continues to have a full complement of key management personnel, which is essential for its smooth functioning and compliance with regulatory requirements. 5. Penalties for non-compliance. Penalty for default in compliance. Subsection 5 establishes penalties for companies that fail to comply with the provisions of this section. If a company does not adhere to the requirements of appointing key managerial personnel as outlined in Section 203, the following penalties apply. For the company may be fined an amount of up to 5 lakh rupees. For defaulting directors and key managerial personnel, directors and key managerial personnel who are in default may be penalized with a fine of up to 50,000 rupees each. Continuing default. If the default continues beyond the initial period, an additional penalty of 1,000 rupees per day may be imposed, with the total penalty not exceeding 5 lakh rupees. These penalties are designed to encourage compliance and ensure that companies maintain the required governance structures and managerial personnel as per the regulatory framework established by the Companies Act, 2013. For more details, contact us.